Good evening, everyone. Law Students Association of Sri Lanka extends a warm welcome to you all joining us today for the webinar series on rent and lease. I am Nadisha Chandasiri, a member from Fabona unit of Sri Lankan Law Students Association. Before moving, let me give a brief introduction. What is Law Students Association of Sri Lanka? Law Student Association of Sri Lanka was established in 2009 as an independent, non-profit and non-political association that represents all law students in Sri Lanka by the patronage of the inspiring judge, the late Dr. C.G. Veeramanki, with the hope of to focus the development of social character of law students that facilitates the academic coordination and cooperate among the vast number of Sri Lankan students who are receiving their education at various institutes. Also, we are proudly represent the National Chapter of Sri Lanka as the Law Students Association to the Asian Law Students Association, which is an amalgamating of law students from all over the world.
Recording in progress.
Asian countries. So let me give the online platform to our dear President Senat to speak some words from onward. Floor is over to you, Senat.
Thank you, Nadisha. A warm welcome to all of you joined us today. This is the second phase of Law is Life, where we look at certain issues pertaining to the law, the relevant laws applicable, and how you can resolve those issues. Today, we have Mr. Chatra Galhen, a prominent attorney at law, joining us today to educate the general public on rent and lease. I will hand over to Farah, the moderator, to introduce the speaker, and you can, whatever questions you may have relating to the topic, you may send us your questions on the comment below, and we hope to answer your questions towards the end of the discussion. Thank you.
Thank you, Zenith. Our speaker today will be Mr. Chatra Galhen, attorney at law, who is the present lecturer for the law of property at Sri Lanka Law College since 2014. He holds a master's in law from University of Newcastle. He is the vice president of the Colombo Law Society and also the editor of Medico Legal Society of Sri Lanka. Pleasure to have you here with us today, sir. Without further delay, I shall move into the questions. Sir, my first question for the day is, what is the difference between a rent and lease agreement? Lease or monthly tenancy?
Yes, thank you, Farah, for the introduction. And before just giving a direct answer to your question, I will briefly outline, at the outset, I will briefly outline the law relating to lease and rent in this country. Basically, the basic law with regard to lease or rent is the Roman Dutch law. There's a piece of legislation or a statute called the Rent Act, number 7 of 1972, which governs some specific premises. It is not applied to all the premises which are subject to lease or rent. So the applicability of Rent Act is totally different to what we are going to discuss today. So Rent Act is totally a different piece of law which has a total independent existence from the common law principles. Common law in the sense the Roman Dutch law principles. So what we are discussing is the entirety of our discussion will be on the common law principles. So the common law which applies to the general rent or lease contracts or agreements or the landlord and tenant relationships. So coming into your question, the question was, what is the difference between rent and lease? Now, technically speaking, if I very broadly answer your question, those can be used interchangeably because it is not, there's no strict definition as to what is lease or what is rent because we use it interchangeably. There's no technical error in using either in different instances. But to be specific, lease are for periods over 1 year. Generally, right? This is not a definition. I'm just telling you these are interchange. These two words can be used as synonyms or as interchangeably in the place where a landlord and tenant relationship is being created. What is landlord and tenant relationship is somebody lives in someone else's premises. So if I am not the owner of a premises, I have to either live as a licensee or a tenant or a trespasser. Either of those three have to. Trespasser is illegal possession. Licensee means there's no rent or lease relationship, but merely on the permission. The third or the first category is the lease or rent. So when the primary requirement in a lease or rent agreement for the purpose of occupation, in return, the tenant pays something to the landlord. There's a payment being made. There's a sum of consideration being exchanged between the two parties for the purpose of occupy. So in licensee, that doesn't happen. That is permission without permission given to stay or occupy a premises without paying any rent or lease. So technically speaking, the question, direct answer to your question is lease and rent both are the same, where one will occupy someone else's property, paying something in money for a period of occupation, but in a technical sense or in a literal sense, this is not legal, right? There's no legal difference, but in technical sense, we can say lease is for a long period, rent is for a shorter period of time. If monthly, weekly, hourly, for 2-3 months, it will be rent. If it is go beyond that, it's like 6 months, 1 year, or 5-6 years, it will be lease. So that is the basic difference in that.
Thank you, sir. Yes, sir. Thank you, sir, for the clear explanation.
Yeah.
My next question is, sir, what is a rent or lease agreement?
Yeah. Now, for a rent or lease agreement, to have a rent or landlord and a tenant relationship. So rent and lease, the principle behind is the landlord and tenant relationship. There's a person called landlord who's the owner of the property, and the tenant. Tenant is the person who occupies by paying something. So to create that relationship, the requirement is occupation and paying something in return in money. So there is no hard and fast requirement to have a written agreement. Agreement can be oral. So if I have a property, I can allow you to stay there, and if at a period like every week or every month you are paying me something in money, even though there is no lease agreement, there's no rent agreement, that means there's no written agreement, we have created the landlord and tenant relationship. Agreement means, strict sense, we are referring to a written agreement. So if it is a written agreement, there must be, if it is over 12 months, remember, if it is over 12 months period, basically a lease agreement must be done according to the provisions of Section 2 of the Prevention of Frauds Ordinance. That means it must be in writing. It must be signed before a notary public and 2 witnesses. And whenever it is signed before a notary public, he has to give a serial number and it has to go for registration. So it is not in Section 2 of the Prevention of Frauds Ordinance, but it will go for registration. But if it is less than that, there's no requirement because there's exemption. If it is, there's exemption that if it is less than 12 months lease, monthly rent, monthly payment of lease, there's no requirement of having a notarially executed document. But the only advantage of having a document, having a lease agreement is that in an event of a dispute, as long as things are smoothly running, parties are in agreement, parties are doing their things correctly, there's no issue of agreement or contract. But when things go wrong, that means when there are disputes, when there are differences between parties, it will be very easy for adjudication or settlement of the matter if there's an agreement. Oral agreements, it will be very difficult to prove. Say you and I have oral agreement, you say something, I say something. No one will, some will believe you, some will believe me, right? There's nothing for a court or an arbitrator or an adjudicator to look at. But if there's a written document, whether registered or not, it must be registered if it is over 12 months. But if there's a written document signed by both parties and both parties accept their signatures or entering into that, that will be an advantage at the instance of a dispute or an issue arises over the landlord and tenant relationship. So agreement means a written document, registered or not, signed by both parties, preferably with witnesses, having conditions of the rent. Basically, what are the conditions that should be there depends on your requirements. Okay.
Right. Thank you, sir. My next question is, in that case, what are the documentations needed from the tenant or tenants?
Now, basically, from the tenant's side, the most important thing is the identity. You don't need anything because tenant has nothing other than the occupation. Because now, if I am a tenant, I go to a place, I don't mind, in strict sense, I don't mind whether that person owns the property or not. If somebody gives me a premises on lease, I will occupy. So generally, we don't, a tenant will not ask for the title deeds or the ownership or things like that. On the other hand, the landlord or a notary or a lawyer who look after this must basically make sure the identity. Say impersonation will go for an issue. Say I hide my identity and go as someone else. So I enter into an agreement in another name, giving a false identity. So when the things go wrong, or when there's an issue or a dispute, then against whom you are going to take action will be basically an issue. Therefore, always it is primary requirement is to make sure the identity or ensure that the identity of the tenant is properly identified. So since you asked about the documents that the tenant must provide, the landlord must always make sure that the tenant is properly identified. Right? Okay.
Thank you, sir. My next question is, sir, as you explained earlier regarding how a rent agreement is not a compulsory, but it's useful when things go wrong. So what happens if a tenant stays without a rent agreement?
What happens when a tenant stays without a rent agreement is, at the moment, say you are talking about an instance where there's no lease agreement, right? There's no written agreement. At the moment the tenant stop paying rent, your landlord and tenant relationship cease to operate, right? Your landlord and tenant relationship in absence of a written document exists only as long as you pay rent. At the moment you stop paying rent, your relationship comes to an end. Then that person becomes a overholding lessee. That means overholding lessee means a illegal occupant. Illegal occupant must be dealt with by legal means. So you have to send him a quit notice. There's a notice to be sent. We are talking about an instance where there's no written agreement, right? If there's a written agreement, they are strictly not necessary to send this notice. But if there's no agreement, you have to send a letter saying that you have not paid the rent, therefore you are now overholding lessee. Please evict or leave the premises and hand over the vacant premises to my client. Basically, this can be sent even by the client, but generally in general day-to-day activities, we send it through an attorney at law. So like a letter of demand, we'll call it a quit notice. And under the common law, you need to give 30 days notice, right? 30 days, not 14 days. For normal letter of demands, we give only 14 days. When you're demanding money for damages or anything like that, you have to ask for 14 days, but here you have to ask 30 days. 30 days notice given and saying that before this date, you have to quit or evict the premises and hand over the vacant position to the landlord. If not, we will be taking action in an appropriate court. So if somebody is not paying rent and staying, consequences will be filing action. And when an action is filed, what are the remedies available? We'll discuss. I think you have other questions on that line also. So basically, if the person is not paying rent, he is liable to be evicted from the premises.
Right. Thank you, sir. My next question is, what is the procedure in signing a lease contract?
As I told you, if it is an informal agreement, that means informal in the sense, less than 12 months, you don't need to register. Therefore, it's basically you enter into an agreement like a business contract, like a commercial contract, no need for a notarial execution. That means no need to have it registered and notarially executed. You can include all the conditions, whatever you want, because these are common law principles, common law government agreements. There's no hard and fast rule what you should include, but basically the how much to be paid, when to be paid, how the repairs to be done, what are the liabilities, obligations of the landlord, what are the obligations of the tenant, that will be included, and both parties will sign the document, preferably with two witnesses from either side. That means one witness from the tenant, one witness from the landlord. Because the thing is, if you deny your signature, if you say that, if the one party says, no, I didn't sign, then that witness can be summoned and asked whether he has signed or not. For that purpose only, you need the witness. Witnesses to a document will not have any explanation to be given regarding the contract or the terms or about the agreements that they had. Only thing that they will witness that this particular person or persons have signed, placed their signatures into this document. So that is when it is an informal agreement. Formal agreement, same condition, same thing, but will be done by a notary public and will have a attestation. Attestation means the notary public will attest and say who signed as witnesses, when he signed, and have to pay a stamp duty of 1% of the total rent. Total rent in the sense, if it is 1 year rent, it is a lease agreement for 1 year, the total rent that you are supposed to pay within that particular period of agreement, 1% of that must be paid as stamp duty. And once it is notarially executed, it will be registered in the relevant folio in the land registry. So, technically speaking, when it is registered, when it is notarially executed, it will automatically be registered in the relevant folio. But to prove that there's a landlord and tenant relationship, even an informal agreement will be sufficient. But according to the Prevention of Fraud Ordinance, if it is over 12 months, it will not be considered as valid or will not get the priority by registration if it is not being done according to without following the relevant provisions. Okay?
Thank you, sir. Thank you for that very clear explanation. Now there's a process where you keep a security deposit in the beginning.
Yeah.
So what is this security deposit and how to claim it after the rental period is over, and how it is done?
Yeah, security deposit, there is no hard and fast rule. That is also depends on the understanding between the parties. Generally, you keep security deposit for two purposes. One is for the in an event where the landlord feels that tenant is not going to pay rent. I mean, all the tenant defaults paying rent, he should have a security to cover it for, not for the entire period, but for a particular period of time, at least for 3 months, 6 months, likewise, depending on the agreement, depending on the property, depending on the value, it differs. One is that to minimize the risk of non-payment. Number two, the security deposit, the second reason is at the end of the lease period or period of rent, if there are any damages done, if there are any non-payment of utility bills or things like that, then it can be covered. It can be covered using this security deposit. And you also ask how it to be repaid or reclaimed. General principle is at the end of the lease period, if you vacate the premises, if the tenant vacates the premises, at the time of vacation, the landlord must pay it. So until it is being paid, the tenant also have a right not to vacate and go. I mean, say 31st of January 2022, you have to vacate. Then the landlord can't say, I will pay it after 1 week or 2 weeks or in 1 month. You have to simultaneously pay it. Until it is being paid, you can hold into the premises. We call it a lien of deposit. In lieu of deposit, you can stay, but the most correct or appropriate procedure will be simultaneously at the time of vacation. The landlord will check the utility bills and the physical condition of the premises, and if there are no claims to be done, security deposit must be returned. If it is not returned, you can stay or you can vacate it and claim it from the landlord. Either way can be done. Right?
Thank you, sir. Now, there are situations and issues arising where the tenants usually make changes to the property or to that rented premises as their own.
Yeah.
What is, is it possible? Can it be done?
Technically speaking, it is not permitted. A tenant cannot make structural alterations or changes to the premises subject to the permission being granted by the landlord. If the landlord says, okay, you do it, you think that you have the bedrooms are too big, so you want to partition it. So you do it by your own, say it's a temporary partition by a screen or something, that's no problem at all. But if it is a permanent nature, the change is having a nature of a permanent change, permanent structure, it is illegal. One thing, it is illegal. Number two, generally we consider doing a structural alteration to the premises is a violation of the lease agreement. So that might be a ground to ask the tenant to vacate the premises even within the lease period. Right? So without permission. Next thing is, if you have done anything, you can't claim it. That means you can't say, I have spent 100,000 rupees for this development. Say, I have renovated this washroom with new utilities, so I want the money back when I'm leaving. You can't do it. Only way you can claim it is if you have done, you say that your bathroom or the washroom is in a bad condition. So then the landlord says, okay, look here, you go ahead and do it, and I will deduct from the rent or something like that. Then you do it and you can claim. So silently, without informing the landlord, if you do any modifications, improvements or repairs or something like that, you can't claim it from the landlord at the end or during the pendency of the lease agreement. So if in strict sense, tenants are not supposed to do any alterations or structural changes to the property.
Thank you, sir. Just a follow-up question to that question. Can we make small changes? Would that affect the relationship?
Like whatever does not change the structure of the building, you might be able to do. But it's always better before doing anything to get the consent of the landlord. But minor repairs like changing a leaking pipe, changing a bulb, or like small things like that, of course, because those are usables, durable stuff, like whatever have wear and tear, yes, you can. But if you say that you don't like the color of the tile that was fixed to the floor, you remove it and fix a new one, I don't think those can be allowed. But whatever you are going to do, it's always better to have the consent or the permission of the landlord. But if not, end of the day, you are running a risk of either being evicted due to violation of your lease agreement or losing your investment, because when you are leaving or when you are handing over the possession, you cannot reclaim it. Those are the consequences.
Thank you, sir. Thank you for that very clear explanation.
Yeah.
My next question is, can a landlord increase the rent during a tenant's stay, that period?
If it is a lease agreement, during the lease agreement, of course, you can't increase. During the lease agreement, say it is for 1 year, you have agreed for a particular amount of money as a monthly rent, you have to fix to that. Whatever the reasons occur in between, landlord cannot agree unless the tenant agrees. If the tenant agrees, there's no problem. But if not, intermediary increases are not allowed. But at the end of the period, say you enter into 1 year lease, so next year also the tenant want to stay. So when you are entering into the new agreement, of course, your terms, even the terms, not only the rent, but even other terms can be changed. But remember, there's another issue. In some agreements, it say this agreement is for 1 year, but on the mutual agreement between the parties, under the same conditions, you will extend it by another 1 year or 2 years or something like that is included in the lease agreement itself. Then you can't change. Or third category is you say without any change, but subject to increase of rent by 10% or 15% or 5%, whatever. Then you have to follow it. Then that is even though there's a fixed period for the agreement, there's a continuation of that landlord-tenant relationship one after the other. So in those circumstances, within the four corners of the agreement, you can make alterations. But say if it is an open agreement in the sense there's nothing about a renewal. Then after the period of lease, same parties can enter into a new agreement with totally a different set of or new set of conditions. There's no legal barrier for that. Right?
Thank you, sir. Yeah. What are utility payments and how are they paid, sir?
Yeah, utility payments are what the tenant or occupier uses. Utility means that generally on normal circumstances, it will be the electricity and water. But today's sense, those are different. There will be a television connection, this dialogue go, POTV connections, router payments. Those are included now, right? Those were not there earlier, but now these internet connections and cable network television networks are just, it's a household thing now. So those are also included. Generally, this is all are general, right? Because there's no statutory or strict practice of this. Generally, the utility bills are being paid by the tenant because he's the one who uses, right? You pay for the usage. Some agreements are there, especially when these condominiums are given. This television, this dialogue go, POTV television bills are being paid by the landlord because that was included, because that is fixed. I mean, it doesn't change. Water and electricity is different. Same house, one person living may be different utility usage of electricity, other person might be different. So generally on water and electricity, the landlord never pays. It will be the tenant who pays. And other common thing is in condominium properties, there's something called maintenance fees. You have to pay a maintenance fee for the maintenance of the common elements, right? Maintaining the common elements, you have to pay something called maintenance fee. Generally, the maintenance fee is being paid by the landlord. And in addition, every year for any premises in the in any area, you must pay a municipality or local authority rates. We call it taxes. Singular, we call it varipada. That is, those are being paid by the landlord. Utility bills are being generally being paid by the tenant. That also can be agreed otherwise, that means in a different way as desired or in the wish of the parties. Right?
Thank you, sir. Is the landlord allowed to enter your premises during your stay?
Yes, but with prior notice. Merely because landlord is having a spare key, he cannot just open it and enter the premises. Generally in agreements, we put a clause, we include a clause saying that the landlord with prior notice to the tenant during the daytime or during the time the tenant desires can enter into the premises for the purpose of inspection. Even if the agreement does not say that landlord have a right to enter, but important thing is it must be because there's occupier. He might have valuables, he might have his privacy issues, all these things, but always landlord has to inform the tenant before coming, and there must be a purpose. You can't just say, I am going somewhere, I want to just come and stay over for 1 hour. You can't say that. There must be a reason, like to inspect the premises or just to see whether the things are in good condition. For a purpose, you can enter and visit the premises, but with prior notice. Right?
Thank you, sir. There's also a question we have received from Facebook in relation to this. That is, can the landlord enter into the rented premises in the absence of the tenant?
No, of course not. Absence in the sense, say if the tenant is not to be found, say for 2 months he has not paid the rent, he is not in occupation, then of course you can enter the premises and see what's happening. But if the premises is under occupation. If it is under occupation, right? If it is under occupation, of course, you can't enter. It can even go into the extent of trespassing, right? It is trespassing, right? I mean, because you have given it on rent. So you have given the legal right to occupy. So you can't just enter. Free entrance or free entry is not available. You have your right to enter, but with the limitation of consent from the tenant. Subject to that.
Thank you, sir. My next question is, sir, what is the procedure if you are a tenant and you want to move out earlier than the agreed period which is there in the rent agreement?
Yeah, so the requirement is that there must be a termination clause. It's very important that there must be termination. If there's no termination clause in the agreement, because as I told you at the beginning, conditions, there's a privity of contract. That means the freedom of contract. Parties can enter into the contract as long as those are not illegal or contrary to public policy or moral values. You can enter into any condition, whatever you want, subject to few limitations, as I told you. So there can be agreements with termination clauses and without termination clauses. If it is without a termination clause, of course you can't leave. Then you have to forego your security deposit, or you are liable to pay the rent for the balance period. But if there's a termination clause, you have to follow the termination clause. That means the termination clause will say how many months notice must be given. If it is maybe 2 weeks, 1 month, 3 months, depends. I mean, it depends on how the parties agree. So you have to strictly follow. So if you want to leave early, you must give the specific period of notice as specified in the agreement. You can't do it without following that. If there's no termination clause, there's no general provision or a common law principle that applies. You have to stay there, or even if you leave, you are liable to pay the rent for the rest of the period. Right?
Thank you, sir. My next question is, sir, now there are situations where the landlord can evict the tenant from the premises. What are these situations, and can a landlord actually evict a tenant from that premises?
Eviction, in the sense, eviction comes into play in two instances. One is breach of lease agreement. That means either you are not paying the rent or you are doing something which is not been agreed. Payment of rent is the primary thing. As long as the rent is paid, your primary requirement is done. But that is not sufficient. You have to do the other things. If you are doing a destructive thing, if you are destroying the premises or being a nuisance to the neighbors, or you got to know that you are doing something illegal or immoral inside these premises, then you can ask the tenant to evict or leave. If he does not leave, the landlord has to resort to the court procedure. Court procedure is to give him notice, a quit notice must be sent, and then file action in the district court of the relevant area. The other thing is, after the period of lease, say, give it for one year lapses, then he continues to stay. Then also the same resort, what you have to do is, you have to send a quit notice, and which will be followed by a litigation or action filed in the district court for the purpose of eviction. Right?
Thank you, sir. That means if a person is staying even after the rent period is over, then this is the process he should follow.
Yes, there's no shortcut procedure, because it must go through a court of law. Then, I mean, we all know that there's a delay in law in our country. So there are cases where tenants are occupying the rented premises for maybe 5, 6, 7, 8 years because of the prolonged court proceedings. But end of the day, you have to leave the premises, and you might be liable to pay damages, unpaid rent, like things you are might be liable to pay.
Thank you, sir. So, follow-up question, sir. Is this the only option available to the landlord in this case, or?
Yes, it's a very unfavorable situation for the landlords, but there is only available remedy, because if the landlord cannot get it by force. Landlord can't go into the premises and saying that I have a spare key, I enter into the premises. Then if the court proceedings, there's something called Section 66 actions filed in the Magistrates Court under the Primary Court Procedure Act, where if the possession is disturbed or dispossessed parties, police will report facts to the magistrate. The magistrate will look at who has been in possession immediately 2 months prior to the facts being reported. So if it is the tenant, he will get the possession back. So there's no shortcut procedure. If the tenant is living without payment of rent or after the lapse of the period of lease agreement, court proceedings must be instituted. So once the court proceedings are instituted, it will go on the normal court procedure. So there's no shortcut procedure, though that will take a considerable time. But it is not, maybe will not be a very difficult case to prove. You don't need to call so many witnesses, but with one witness you can manage the case. It will be not a difficult case to prove, but yet it will take some time and some energy and money has to be spent by the landlord. But all can be recovered. That is the thing. Damages, case, cost of litigation, unpaid rent, all can be recovered. Right?
Thank you, sir. My next question is, sir, now there are situations we have seen where the tenant lives for like a very long period of time. Now my question is, now if a tenant is living for more than like 20 years, does that give him or her the right to ownership to that property?
No. Once a tenant, the principle is once a tenant, always a tenant. If you enter into a premises as a tenant, you continue to be there as a tenant. Only difference is we know that there's something called prescription law. Under prescription ordinance, section 2, section 3 gives the right for a trespasser or an independent possessor to claim prescriptive title. You can claim title or ownership to the property after 10 years in independent possession, but that will not happen as long as you continue to be a tenant. So your tenancy relationship must be terminated by either a notice or by an overt act. Overt is a very common act. You get into a fight, go to the police, go to court and say, I am not going to pay you rent hereafter. And if from that day onwards, if you continue to be there for 10 years, then you have the right to claim for prescriptive title. Merely because you have been there for 10, 20, 30, 40, 50 or 100 years, as long as you pay rent, you are a tenant, and a tenant is a person who lives under the owner or accepting the ownership of the landlord. As long as you accept someone else's ownership, you are not qualified to claim ownership. Only exception is you have to terminate the tenancy relationship by some means, which you should have proof, and from that termination, continue for 10 years. Then your the remedy is the prescriptive title. Then you can claim for prescriptive title. That is there are cases like that. So there are, in case law, you can find cases like that where people have succeeded, tenants have succeeded, but yet general principle is once a tenant, always a tenant. Okay.
Thank you, sir. Thank you so much. We have received some questions from our Facebook, during this live session. My question is, sir, what are the things a tenant can do if the landlord rejected to pay the security deposit at the end of the tenant period, even though he has completed all the liabilities and all?
As I told earlier, there are two remedies. One is take it as a lien. Lien means take it hostage. Continue to stay without leaving until the security deposit is paid. Remedy number one is that you can say, I'm not leaving, I'm not going to pay rent, I have fulfilled all my requirements, I have fulfilled everything. If you are not paying, I'm not going to leave the premises, and continues to stay. Then he's not a overholding lessee. He's staying in lieu of the security deposit. Second remedy, you leave and then claim it by way of damages. You can send a letter of demand, and if it does not honor, you have to go for litigation. Those are the only two remedies available.
Right. So thank you so much. The next question is, sir, in terms of compensation, what action can a landlord take if the tenant destroys the premises?
Destruction is of various types. Like if it is a total, I don't think there will be a total destruction, but if there are any damages being done, primarily it can be recovered from the security deposit. If the security deposit is not sufficient, then you have to demand it and claim it by way of a court action. If the premises has been badly damaged or been destructed, rather than destroying, destructed, physically damaged, then you have to claim it by way of a money claim. It's a damage claim, normal damage claim. So it must go through a court proceeding, district court proceeding of money recovery action.
Thank you, sir. The final question for the day is, if the tenant has not done a reasonable inspection at the beginning of the tenancy, what are the options available to complaints of damages to property which was not done by the tenant?
The question is not clear. I mean, who has not inspected at the beginning? Tenant.
Yeah. What are the options available to complaints of damages to property which was not done by the tenant if the tenant has not done a reasonable inspection at the beginning of the tenancy?
No, maybe not at the beginning, but when you're occupying the premises, if there are any issues with the building, say there are cracks or broken doors, broken tiles, those are the common things, no? Broken walls or things like that, you have to immediately bring it to the notice of the landlord. Immediately, I mean, like as soon as you get to know or notice it, you immediately when you notice it, you have to bring it to the notice of the landlord. And if the landlord claims that, no, I am not responsible for those, you are the person who has created it, then of course there will be an issue. There is a dispute which has to resolve by some intervention of a court or arbitration or an intermediary party. But it is always saying under common law as well as English law, the buyer must be aware. So if the tenant does not inspect the premises properly and lease out or go into a premises which has physical defects or damages or something like that, and just ignore it, and at the end of the period, if the landlord says, no, these were done by you, tenant has to basically bear the risk of paying the sum, because if it is not being noticed even during your tenancy period, it deems, or it like, who will believe you that it was there, right? If it was there, as a diligent person, diligent individual, you must bring it to the notice of the landlord. If you have not brought it to the notice of the landlord, you must at least undergo the risk of compensating or paying back the quantum of damages that has been there. Right?
Yes, sir. Thank you, sir. That was very clear. Yeah. We have come to the end of our session, and I thank Mr. Chatura Galhena for giving us very clear explanations on all the questions we have. Now, to give the vote of thanks, I invite Nadisha.
Thank you very much, Farah. So, have you heard the way we say the best things and most beautiful things in the world cannot be seen or untouched? As that, all things we have to touch by our heart. Thank you very much. Is one thing that we can bring before you. I consider it's a great privilege to propose a vote of thanks to all of you who have witnessed with another session of memorable and successful event of educational webinar. On behalf of Law Association, I would like to thank our guest speaker, yes sir, Mr. Chatura Galhena, who graced us with an eminent knowledge and set up the perfect platform for our webinar. Also, these events are not come overnight. It will started from the beginning with the advance of months. As we are fortunate enough to have a backup team with a motivated and decided, dedicated students with voluntary services. My heartiest thanks go to all the members and the committee members of those student associations, and also your brother Nirmal for handling the live session. Finally, and how can we forget the scholar guide who have given us the sponsorship. Thank you very much all. Last but not least, I would like to thank all the listeners who are coming with us by listening and giving your interest in this program. Before leaving us, once again, I take this opportunity to say thank you very much for all being virtually assembled here. Let me say, before we are coming in, let's meet again with the educational webinar very soon. Till then, stay safe. Thank you very much.
Recording stopped.